I have the great honor and privilege to start the second session of this launching of the ELI Romanian Hub. This is a panel on the legal dialogue, interprofessional dialogue. We have a very generous topic, the new frontiers of the law, current challenges in the digital and multipolar era. We have 4 speakers in this panel, and I would need a whole conference to introduce each of them. The topics they are going to address represent just a starting point, an invitation to a reflection on that common core of the European law. The first to take the floor is Professor Marieta Safta. You all know who Professor Safta is. She needs no introduction. Professor Safta is going to speak about how we could rethink the Constitution and what the digital constitutionalism is all about. This is a topic I am particularly very interested in. Thank you very much for the introduction. As I was saying in my introductory speech this morning, today's interventions, even on the scientific side, are intended to start some directions of research. And this is why I selected this topic for today's intervention. And I am going to propose a rethinking of the constitutions. In many of the speeches we heard this morning, reference has been made to the artificial intelligence and to how it influences us, how it influences the legal institutions and our lives, and how it makes us vulnerable. The president of the European Law Institute actually refers to a series of vulnerabilities that we are currently experiencing. As you've noticed, many of the conferences we attended lately, be it in Romania or abroad, focus on this topic. I've recently attended such a project in Poland, and on that occasion, we tried to come up with different approaches as to how the artificial intelligence influences the institutions, the legal institutions. In the literature, as I said in my presentation, there is a constellation of initiatives that are directed towards a progressive constitutionalization of the digital space. We are indeed speaking more and more of a new concept, the digital constitutionalism. This concept is subordinated to the constitutionalism in the virtual environment, if you consider the platforms and how they influence our life. As far as I am concerned, I am proposing an approach that allows us to connect this debate on the evolutions of the digital constitutionalism to the traditional constitutionalism. That is, more precisely, how the structure is structured and what it means. After seeing other initiatives at European and international level, I think that we are now living a so-called constitutional moment. This is not an original concept. A series of recent works bring to the attention this idea. This constitutional moment means a recalibration of the constitution. Constitutions are little by little becoming obsolete. We can say that we can interpret them, but how far can we go in this interpretation? How elastic is this constitution in order to adapt to the challenges brought about the digital constitutionalism? I was saying that these ideas and the initiatives as to the recalibration of the Constitution have emerged both at European and international level. Very recently, in France, there has been an attempt to develop an artificial intelligence charter targeting a series of specific rights. And of course, we are all familiar with the legislation adopted at the level of the EU. Another initiative in this respect emerged in Chile. And very recently, there has been a discussion about the revision of the constitution in Greece with proposals regarding the explicit enshrinement into the constitution of the fact that artificial intelligence should serve the individual freedom and social prosperity. Now, leaving aside other introductory elements, in order to make it short, because all these papers I'm talking about will be at some point published, I am going now to focus on these ideas related to this interconnection system. And my idea concerns a mapping of every article of the Constitution in order to see where these adaptations are necessary. These are just proposals, and of course, other proposals may emerge from the debates. These new principles, new rights, or new guarantees can be then explicitly enshrined in the Constitution. And when we speak about the Constitution, the first chapter is the chapter on the principles. If we were to take these principles one by one, we can think of a recalibration, but I will focus on the rule of law and the sovereignty, because I think these two concepts are particularly impacted by the technological developments. If we speak about the development of the rule of law, I would like to dwell on the idea of responsibility. And there is a whole range of criteria defining the rule of law. We also have a document by the Venice Commission, the rule of law chapter. But what drew my attention were those discussions where we do not necessarily speak about the errors that the artificial intelligence might generate, but what is related to the rule of law, the transparency, what is beyond the decision. Because in an algorithm society, citizens may be familiar with the legislation, but they may not be familiar with the algorithm for the implementation of the legislation. So only one of the guarantees of the rule of law might require recalibration in this respect. Rewriting of this principle, saying that the use of artificial intelligence and digital technology in the exercise of public authority should be subordinated to the legality, the transparency, the human responsibility, the democratic control, and the actual access to jurisdictional remedies. We are still under Chapter 1 of the Constitution, the principles. The second principle, the sovereignty. The traditional constitutional model requires that political will is developed according to the traditional models, but part of the public deliberation is carried out in the context administered by private global actors, and the access to information is mediated by the algorithm. Now, considering our experience from 2024, the experience that we had with the Romanian presidential elections, we see that the problem is not related to the actual voting and how, through technologies, the results of the vote can be changed. I mean, the traditional elections fraud. No, I'm speaking here about how the political will is formed. And I think this requires a recalibration in order to introduce a guarantee of the public deliberation and elections participation in line with the digital technology, algorithm system, and the AI. A huge chapter that requires studies related to the fundamental rights. And here the literature focuses on two main opinions. One opinion stating that the existing rights are sufficient, but they require reinterpretation, and another opinion saying that new rights should be included. Of course, both opinions have positive and negative aspects. When it comes to introducing new rights, the question is, where should we stop? Because we should avoid an inflation of new rights. And the question is how vast this new constitution should be. Perhaps a recalibration of the fundamental rights, and we can tackle the whole catalogue of rights in the Constitution. But perhaps we might focus on the guarantees and also provisions regarding more significant controls, the right to challenge the decisions, and very importantly, in that draft of charter they had in France, they also referred to the right of a non-digital alternative. Because otherwise we risk becoming prisoners of technology. So we should always have this non-digital alternative guaranteed. If we speak about public services, for instance, or in any other field, if you can speak of a guarantee saying that no person could be deprived of the exercise of their rights and freedom exclusively as a result of their being unable to use the digital means, because such an impossibility could be caused by a variety of factors. Now, Chapter 3 in the Constitution, the public authorities, we can speak separately about the Parliament. I'm not going to go into details about this. But I saw representatives of the Legislative Council speaking more and more about the involvement of artificial intelligence in the drafting of normative acts, with positive and negative aspects. What does this involvement mean and how far can it go? So, also related to this topic, we can speak about the executive function and the authorities of the central and local public administration, and about how public services are being increasingly digitalized. Here, perhaps we should consider some new guarantees. The right to be informed when the artificial intelligence is used, because we can be selected based on an algorithm, or perhaps based on algorithm decisions are made in the administration. There are famous examples where algorithms were used in the decision making and the results were erroneous and discriminatory. Perhaps we should have a recalibration here, is to introduce these guarantees in the exercise of the administrative functions by using digital systems and artificial intelligence, and to make sure the public authorities are transparent and inform us when they use algorithms. That the human control and the actual protection of the fundamental rights is important. About the judiciary authorities, I think there has been a whole discussion, and the representative of the Ministry of Justice tackled this topic in his presentation this morning. And indeed, there is room for a constitutional recalibration in this respect. The judicial authority and the decisions impacting on the fundamental rights and freedom should remain under the human responsibility and the judiciary independence and the actual judiciary guarantees, irrespective of what technological tools are used. The economic and constitutional order in the digital era and the economic environment are largely impacted by the development of technology. And among the numerous topics that we could tackle here, a topic that has been subject to a recent referendum in Switzerland is the use of cash money. At some point, I read in the official Gazette of Romania an initiative for the amendment of the Constitution. It was a citizens' initiative for this amendment of the Constitution regarding the use of cash money. But you know that citizens' initiative have to go through many stages, and it's a very complicated process. And I have no details as to how it evolved. But the idea is that at some point there has been such a citizens' initiative and such a concern. Because the cash, and I'm not speaking here about frauds, but about the actual constitutional meaning of the cash. The cash has a meaning that goes beyond this traditional economic function. It is a tool for individual autonomy, for unconditional economic participation. It's not conditioned to the access to technology. Digital society obliges the contemporary constitutionalism, as I said, when speaking about the general guarantees of the fundamental rights. It obliges us to include the concept of digital guarantee. A potential direction for a recalibration should mean that the state guarantees a non-discriminatory access to the economic participation and to exclude discrimination in this respect. And the last chapter in the Constitution is intended to the revision of the Constitution. In the first title, a very important doctrine study was carried out, and it is based on a questionnaire that I received in a network on constitutional law, and this shows us how important the collaboration is.
And this allows us to go into a subject of common interest. In this paper that I recalled before of Professor Leisure Galbert and Kevin Fraser, they stated an issue connected to AI use in the revision of the Constitution. Should the AI write your Constitution? Of course, we may think about the impossibility of such a thing happening, but we should take into account the fact that Constitution is more than mere text. It is our identitary document safeguarding fundamental rights. It is an expression of sovereignty. It can offer benefits when it comes to documentation and drafting, but it cannot replace the democratic expression of sovereignty, which is above the Constitution as a text. That is why we should add new limits to the revision of a Constitution. We have these limits enshrined in Article 152 in the Constitution. In the process of drafting and reviewing the institution, we can use digital tools and AI tools only as auxiliary means of analysis and support. The initiation, deliberation, and approval of constitutional amendments should lie with the competent authorities and the sovereign will of the people. And I mean by that, that kind of will which is shaped free from algorithmic manipulation and which is more and more difficult to secure. In conclusion, each of these levels can be developed. Together, we can identify new ideas if you resonate with the main idea, namely that the Constitution should be amended and that we cannot stick to the current texts and safeguards, which I really don't know how long or how much they cover the current issues and challenges, those that the society at large is faced with today. That's why I conclude that in this stage, constitutional right should safeguard that technological progress stays consistent with democracy, sovereignty, and free will. As the president of the European Law Institute also mentioned in her opening word. Thank you so much. Thank you for this intervention and for the fact that you highlighted the fact that AI should be at all times controlled by people. People should be inside the decisional loop, and they should serve the interest of people. Indeed, we are forced to make room for AI in our life as the judiciary. The second presentation, I confess that I wouldn't have thought of an artificial reality before, a reality which is influenced by artificial or non-human intelligence, as someone taking the floor before called it. We are in for an introspection on how the challenges of artificial reality impacts the traditional law system. Professor Crânguța-Leaua has the floor. Good afternoon. It is a great privilege to speak before you today. especially in this very special institution which expresses Romanian thinking and the intersection of Romanian thought and international thought. I'm very impressed, and please allow me to confess that I feel very nervous, almost as a student speaking here before you. Why? Because we ask why, and this why refers to the premises of reality. And this analysis of reality helps us think about a system of law. I dare say that there are some implicit suppositions that underpin the law, and they are fundamentally caused by the current technological developments. I will refer to the fact that our suppositions on reality, our suppositions on legal norms, our suppositions on the space, time, people, and our suppositions on truth, all of them are right now questioned in order to be rethought after this fundamental technological evolution. And when I speak about fundamental technological evolution, I don't have in mind just the AI, although it has mesmerized and charmed all of us. So we keep thinking about it all the time. But in reality, there are two other technologies that have generated a complex structure of artificial reality. I call it artificiality in one word. The technology of artificial reality made up of artificiality and augmented reality that bring the visual elements in the whole equation, such as a hologram in this room, blockchain technology on which uniqueness in the digital good relies. We cannot have assets if they don't have economic value. There would be object. Digital objects can be multiplied infinitely, like my presentation. It wouldn't be valuable unless it is unique. From the legal point of view, intellectual property right, protected idea, so it is the same with blockchain, with digital assets. That's why we can have digital assets, because we have blockchain. It also brings automation of behavior, of conduct, everything that we call a smart contract. I don't translate it into Romanian. I translate it like an automated contract, not as an intelligent contract. This also changes the parameters of reality. As a consequence, all these creators of artificiality and AI have created a space in which we carry on our lives as human beings in an artificial environment. This artificiality presents enough reality and consistency to be different from natural reality. I have an intellectual challenge for you. What does it change in matters of law? I will take each aspect one by one, trying just to ask questions. The classical premise on reality, and the whole system of law was built on that, modern law especially, is that there is a single legal relevant reality, the physical reality as a perceptible world directly or through tools. With secularization, because before it was different, we eliminated from the current mindset an idea of transcendence, a certain idea of spirituality. So now we have just one layer, not just physical and spiritual worlds. These are the premises of the law. But this premise has been changed. Why? The natural world is no longer made of just one layer. There are two, artificiality and reality as such. But if we combine this artificial reality with AI, it creates an alternative reality to the physical world, which is persistent, functions economically, and creates room for social reality. One person can live on several existential areas: the physical world, social media, blockchain ecosystems such as coins, which is different from the monetary system, a metaverse with immersive reality where you can actually carry out complex social and cultural and economic activities. In this structure, the legal concepts are impaired: territory, jurisdiction, domicile, the location of crimes which are connected to territory, the notion of assets, as well as a classification of mobile and immobile goods, which is fundamental to the legal system. Tangible, intangible assets and different systems applying to that. The patrimony, the uniqueness of the patrimony, the connection between a patrimony and a person. Which person? All that is being questioned fundamentally, not adaptively. So an essential question before we answer to any law matter is the following question: in which reality the action manifests, in natural reality or artificiality? Another question: we moved from an independent nature to a man-made nature. The laws of nature, as a classical premise, are independent of human will. The concepts of responsibility or liability, such as force majeure and fortuitous situation, rely on the dependency of human will and the natural conditions of our activities. But in metaverse, the laws of physics are not natural. They are created by the software developer. This environment can be modified. Disasters are not a result of nature, but of human design, which can be, one way or another, problematic. The legal concepts impaired are force majeure, of the fortuitous case, but also predictability, risk. Random risk is risk random when it doesn't depend on nature but on a program. Insurance, a whole field when it comes to risk law, and also responsibility for one's deeds. The fundamental question is the following: when nature is created by man, aren't we faced with another category, namely liability of the one who created this reality? This takes us to the next change that I subject to your attention: from a human subject to reality, a human creating reality. At the beginning, the human being was part of a reality he couldn't create, and I refer here to the worldly reality. In the new reality, through artificial chain, blockchain, and metaverse, a human being is an architecture, a creator, a manager, and a legislator of a new reality, different from natural reality. The legal concepts that are affected are responsibility, because now we have the responsibility of the creator, which is distinct from what we have now, which is exemption from liability. Then a new concept, the public interest and public order. Public interest and public order are connected to community and territorial and cultural spaces where they unfold. They are also connected to the state power. They are more dynamic than the state power. The moment reality is no longer territorially limited to physical reality, whose public and whose cultural space should we pay attention to when it comes to securing interest? And what is this interest? Whose interest? Of the creator of artificial reality or the communities inside?
we have to see what the creator's interest is. If we think in a spiritual manner, the situation may be different, but we stick to the space of the existing law. And this leads us from the legal norm to what I propose to be changed in the future, because we have no other change. The distinction between the legal norm and the technical norm should be enriched by a third category, the legal and technological rule. This third category refers to that category of rules that apply to how we create the artificial reality, the artificial intelligence, the virtual reality. What norms should be applied to the creator of such reality? In the traditional premise, we have the laws of nature and the norms, legal norms that are separated. And the legal norms tell us what we should do, but we have no obstacles as to breach them. So all the part related to responsibility and damages for any breach. But the new reality in the metaverse and with the help of the blockchain allows for the legal norm to be incorporated into the code. And if now, for instance, a person can steal something, when in a virtual environment one cannot make any such action of appropriation, of touching an asset to which you're not connected from an information point of view, you cannot possibly steal, because you cannot physically take this digital asset into possession. And its impact on the legal concepts, the sources of obligations, where do these responsibilities stem from? From the law, from the nature, or from this artificial nature created by humans? Now, the fulfillment of the obligations, the legal sanctions. What do we sanction for? Do we sanction the person for selecting the environment in which they live? We are not sanctioned because we decided to live here on Earth. We are not sanctioned because we decided to live under this natural law. Can we really be sanctioned when we decide to go into metaverse A instead of metaverse B? When we choose a certain space of artificial reality? This is a question. This is a new legal matter. Now, the contractual freedom and the autonomy of will are subject to a rethinking, a new thinking. We have thus a complex situation here. And now I'm coming back to the three parameters that I call parameters that anchor the law. We all know from the theory of law that when we speak about the enforcement of the law, we speak about space, time, and person. These are the three parameters, and all of these three parameters change. First of all, the traditional premise regarding the space says that the space is limited, it is rather stable, and independent of your human will. The economic value is related to this limitation of the space and of the resources in space. An asset has economic value because a person thinks that the asset has a value. If it's endless, they would have no value. Now, in the artificial reality, the space can be endless, can be multipliable, can be relocated, can be instantaneously changed. So we don't even need a certain time period to make such a change. And therefore, geography is thus a design choice and the choice of digital architecture construction. Now, the territorial delineation is also relevant. The concept of asset is important as it requires a relation to the economic value, and perhaps we will even have a concept of creation of artificial economic value, the distinction between fruit and product. This is the possibility to preserve or not the substance of what is being multiplied. In a digital environment, the substance is not lost when a multiplication takes place. Then the real rights, the concept of possession and property, and all the related aspects, and the expropriation. Expropriation is a right of the state in relation to a certain category of assets. And the question is, how present is the state in the virtual environment? Then the first question would be the social relation. In what space is it expressed, and what are the characteristics of this relation? Then the second parameter, the time. What can be changed in terms of time? The traditional premise says that time is linear, irreversible, and that there is a sequence in time. If something happened before another event, there is an assumption of causality between A and B. This is the first presumption, the first assumption that we use. The fact that we first have the cause and then the effect. So the whole structure of the legal liability is built on the impossibility of going back into the past. Well, in the new artificial reality, in the digital environment, in the metaverse, the time can have different speeds. In metaverse A, I have a certain speed of going through the different stages, and in metaverse B, a different speed. In the metaverse A, something happens instantaneously, while in metaverse B, it takes 5 minutes before something happens. And when it happens instantaneously, it happens for all the people. The speed up and the acceleration and deceleration of time are possible in the artificial reality. In artificial reality, events can be resumed. You can experience 5 times one element, and you can go back in time at the point where you want to. So this erases that causal relation with the causability. And this can include the timestamp, the fact of applying a timestamp, saying that the time in the metaverse is same as in the real time, the natural time, but it also includes a predefined future, a future that is deprived of randomness. And this leads to 2 trends. First, technological reversibility and immutability. And they create a fundamental difference of paradigm in terms of status of limitation, in terms of the usus capio, and in the concept of terms, the restoration of the recovery of the prejudice, and the right to be forgotten, the rehabilitation in the criminal law. And a whole series of concepts stem from this idea. And this leads us to a new question. In what kind of reality does the social reality manifest? In speaking about time, if the time doesn't have the same structure in all the spaces where we are present as participants to the civil legal relation. And the third parameter, the person. We move on from a unique person. The uniqueness is given by our own physical nature. And if a person has multiple personalities under the same physical body, we say that such a person is not able to participate to the civil circuit because of a behavior dysfunctionality. The multiple personality syndrome is most of the times a reason of forensic expertise in order to deprive the person from responsibility. If we start from the idea of a person that is identifiable, rather stable and unique, has a completely new approach in the artificial reality. A person can have and has multiple digital identities. When I speak about identity, I do not refer to the fact of having a certain avatar. Nomen tracta fama are the 3 elements of the Roman law. The person has an identity that it assumes, and an identity that is recognized by the others, and an identity called fama that is referred to in the relations with the others. A person can have multiple avatars. We all have multiple avatars on the social networks, and we can also have anonymous identities. As a physical person, as an individual, my individuality never disappears. You know, in the U.S., they have that John Doe name to name those unknown persons, John or Jane Doe. They have a corporal nature. In the digital environment, you can be so anonymous in order for your corporal nature to be just a numerical series. Without any physical component, there is just a string of numbers. In terms of legal concepts impacted, it has an impact on the distinction between the legal and physical person, natural person. there has been a talk about the legal personality of the artificial intelligence. And this component, somehow autonomous behavior of the digital artificial intelligence, and the impact in case of multiple identity. The legal capacity, the consent, the representation, all of these concepts are impacted. And the question we have to ask, who is the holder of rights and obligation when this person exists through multiple digital representations? Or even more interestingly, when the same digital representation is used by several persons, how do we identify the right person? It's such same as actors. They are presented in theater on stage, but in the digital reality they are not. Then we have a change in the exclusivity of the human actor in their social relations. In a very arrogant manner, we removed animals from the social relations. We only have social relations among people. We decided that the law applies only to humans, and animals are just an asset with an autonomous intelligence, but the responsibility lies with their owner. But we should not forget that we do not have the same supremacy. If we manage to be more oriented in the natural reality than a frog or a small insect, this is not the same in case of an artificial structure that could be much more evolved. Now, the legal concepts modified, the legal capability, the natural person, the legal person, the author of the legal act, the guilt, the intent, the conditions of the civil liability, all of these are impacted because we have these autonomous agents, these characters that act in the human appearance, such as Siri, Claude, or Alexa, and all the others, but they are not human persons. And this leads us to a permanent question. Who is held accountable for a decision made by a system that is not a human being, but not a simple tool either? And as I'm reaching the end of my presentation, I am getting to the most difficult part of it, the hard truth, the basis for the change of the concept of truth. The traditional premises stated that the legal truth is built by means of evidence. So we limited what we include as information in the space of truth. The procedures challenging the positions on the subjective truth and how we interpret it, the actual interpretation, and the institutions that have the right to make a decision on the legal truth. So we created a world where the truth has its means of expression when it comes, when it comes to the legal truth. This is an institutional truth. But what does this do in reality? It creates an algorithm-based truth. The blockchain communities and the communities generating a strong evolution of the artificial intelligence propose a truth that it is independent to the institutions. It is registered into the centralized database. This is what the blockchain does, or mathematically calculated truth, but that is independent of the human interpretation or developed based on statistics of future acts. And this shifts the trust from the institutions such as the judge towards the algorithmic judge. And what does this do? I cannot stress enough how important this is, but it kills the minority opinion. It kills, and I'm saying that it kills because the minority opinion is a being for me. The possibility of having a minority opinion, an alternative thinking, the respect for our colleagues, the judges and the arbitrators that have a different opinion than my own, but who are part of the structure aimed at finding the truth together with me, well, this disappears when a decision made by the artificial intelligence is a unique decision. it leads to only one decision, not a group of opinions in which some of majority opinions are the minority. Presumption, certification, jurisdiction, enforcement authority, all of these are impacted. And the question here is whether the legal truth and the algorithmic truth are compatible with the idea of justice. And now, as a conclusion, and I want to say that we are not living a technological transformation, but an ontological and epistemic transformation. Fundamental premises of the realities based on which the concepts were developed change now. The uniqueness of this world, the concepts of space-time, uniqueness of the person, the rules and behavior relation, and most of all, the distinction between nature and human creation. And in my humble opinion, the challenge that you are faced now in this 21st century in the legal world does not consist in adapting the norms to the new technologies, but in re-examining the fundamentals of law, considering a reality that is no longer exclusively natural, but it is increasingly artificial and created by the human being. Thank you.
Vă mulțumim frumos.
Thank you so much for this presentation. I had a feeling that after every door you opened, there was another door and the next question. And we hope that by the end of our research projects, we will come with an answer. The next presentation moves us from artificiality to digital reality, and a concept that also the president of ELI put forward in her opening speech, namely vulnerability. On this topic of vulnerability in the digital era, we invite Mihaela Durnescu to speak, public notary public and president of the Chamber of Notary Public in Bucharest. Madam President, distinguished guests, first of all, let me thank you for allowing me to present the perspective of notaries public on vulnerability in this era of digitalization. As we all know, a valid legal act supposes a valid consent. And before anything else, that means someone understands what they signed for. But in the digital environment, to understand the thing that you sign means to know how to use the digital tool. Digitalization does not change the request, but somehow it changes the barrier, moving it from capacity, which is a formal law category that legally speaking some have, some don't, to competence, to skill, which is a state of fact, the real capacity to operate with a specific system, and precisely to understand its consequences. Between the two levels, we find some vulnerabilities that our classical categories do not often capture. I called it vulnerability by design because it doesn't result from age or disease, but from the way in which digital reality is often projected. Simplifying, we have two populations, one between 15 and 35 years of age, which the literature after Mark Pransky names the digitally native. They lived with the interface, those for which this is the mother tongue. The second category, those more than 50, is the category of those whom the digital revolution found at a specific level of their cognitive development. In the literature by Mark Pransky, they are the digital immigrants. They will speak the digital language with a specific foreign accent. Cognitive psychology distinguishes between fluid intelligence, which is the capacity to perceive and assimilate new paradigms, and crystallized intelligence, which relies on accumulated experience. The crystallized intelligence is developed in time. The fluid intelligence goes up to a certain age and then it stops. To learn a fundamentally new technological paradigm calls on the fluid intelligence. That is why when you find at 55 a radically new instrument, it is processed with a different system compared to those age 15. The digital immigrants will find it difficult to manage with the new system. However, there is one thing to have a certain speed in using the interface, and the other thing is to understand the consequences, legal consequences of something that we do. A young man aged 20 can go through 20 pages of terms and conditions in a few seconds and will press on accept very quickly. But this young man has not consented knowingly, no more than his grandfather, who is struggling to find a button. The vulnerability of the aged one is at the level of access, but for the young one, vulnerability lies on attention and understanding the effects. But they are both vulnerabilities, and both of them difficult to capture. This is not a speculation. Of behavioral study of the European Commission in 2022 measures the effects of manipulating interfaces, the so-called DAR patterns. Exposed to such patterns, 51% of the vulnerable consumers and 47% of those used to these patterns came to decisions which were contrary to their routines, half of them. The impact was higher on those who have a low professional training and, of course, among the old ones. The study also found that 97% of the most popular sites and apps used by the consumers in the EU contained at least a DARN pattern. The design, therefore, can determine a decision that a human being would never make if let alone. This is the vulnerability by design. The Romanian law knows about several types of vulnerabilities, but each of them is built on a different criterion. One is clinical, intellectual or psychosocial disability. The other one is connected to status, underage, refugee, asylum seeker. They are protected by the law by finding a capacity, not a concrete status. And then we have vulnerability as socio-economic vulnerability as defined by the law, entailing the law of not satisfying daily needs. But none of them matches the link between man and instrument for vulnerability that does not come from disease, age, or deprivation, but the way in which the environment is designed, an environment where people are called to make a decision. So my question is the following. Do we have a comprising definition of vulnerability? And does it still cover the digital era? The reform of protecting physical persons connects vulnerability to deterioration of personal capacity. The adult that cannot take care of himself or herself. This is vulnerability connected to the status of a person, neighboring incapacity, thought for a certain type of fragility, disease, advanced stage, or cognitive decline. But this definition is not good enough in a digital context. Vulnerability by design will impact someone who has all its faculty, irrespective whether they are young or old. If we stick to the definition connected to the status, these people are not vulnerable in the sense of the law, although this is exactly what they are. The Romanian law also includes wider meanings. In criminal law, a vulnerable person is not a label, but a state of fact appreciated from one case to another based on the core principle that someone is inferior to another person. This is not just doctrine. The criminal code sanctions more robbery when someone takes advantage of the vulnerability of a victim due to age, health status, disability, or other reasons. So this is an open enumeration because vulnerability cannot be included in a closed list, and the conclusion of the doctrine is clear. The meaning is connected rather to deeds than to law. The Civil Code also urges us to adopt a wider view on vulnerability. When it comes to consent, Article 100 to 1205 says that a contract between a person which is even temporarily found in vulnerability or incapacity to realize consequences as invalid. Article 1216 requires that violence should be appreciated by age, status of health, and the character of a person concretely, not abstractly. And Article 1221 about injuries speaks about a state of need, lack of experience, or other causes. Lack of knowledge can also describe an adult fully capable placed in front of a digital tool that he doesn't master in relation to an operator that programmed the interface as is knowledgeable about it. So vulnerability in criminal law is appreciated by vulnerability, and we should do the same in civil law. The reflex of putting an equal mark between vulnerability and lack to capacity and the age of majority is a formal pattern that sometimes we should contradict. The European case law has already taken this step from form to substance. In Strasbourg, in Javier Lucas versus France from 2022, someone had to resort to the Court of Appeal only digitally using a platform that did not provide for the type of request. He came with the application on paper. It was considered inadmissible by the Cassation Court. The European Court appreciated that imposing only digital means without taking into consideration the practical means is disproportionate. The digital application cannot become so absolute as to cancel a right. In Luxembourg, a Romanian case, Andrei Rădulescu and others versus Banca Românească in 2017. The transparency requirement is not reduced to formal intelligibility, grammar matter. It is a matter of substance. The documents should be drafted in such a way that the consumers can be able to evaluate based on intelligible and precise criteria the economic consequences thereof. The conclusion of the court is that the consumer is the weak part, especially when it comes to the level of knowledge. Therefore, again, we are faced with the vulnerability that I mentioned before. What the court does in Andrei Rădulescu case, understanding from form to substance, is what a notary does. Law 36 of 1995 requires in Article 1 that the notary should ask for clarifications and give clarifications to the party in order to make sure that the parties understood the meaning and the effects. Article 92 requires that after reading a document, the notary should ask the parties if they understood and if it expresses their will. This is not a national particular. This is contained in the European status of notaries, whereby a notary, as underlined by the Council of Notaries in Europe, the notaries, they practice preventative law.
And in order to make sure the dispute is not created, notaries do not check if the boxes are ticked. The notaries check whether there is an understanding reached. European regulation on artificial intelligence prohibits the techniques exploiting people's vulnerabilities. The Digital Services Act forbids the dark patterns, and the future Digital Fairness Act targets specifically the design exploiting vulnerabilities. That pattern where the accept button is big and very visible while the refuse button is very small and somewhere in the background. There is a lot of talk about signing documents remotely, including the notarial acts. This is a very serious discussion in our field as well. We have to be honest and responsible. What can be digitalized without any loss is the part of transmission, archiving, signature, and perhaps at some point the identification as well. What cannot be limited to just ticking a box before without losing the authenticity of the act is the moment when the understanding between the parties is checked. That moment when the individual reads the document, talks to the professional, and the professional is convinced that the person understood the meaning of the document and agreed to the effects thereof. This is a guarantee that was requested in the Andrei case and that can be impacted by the manipulative design. The more opaque the environment becomes, the more manipulated by the algorithm is that human verification is more valuable. The same requirements result from the activity of the ELI. And this is precisely why I am delighted to be able to speak here in front of you. The decisions for automated decisions elaborated under the current director of the ELI ask for automatization never to suppress the exercise of the rights. It should remain an alternative way. These principles require for human revision for decisions that have significant or irreversible impacts. An authentic act may be the sale of a house, the donation, will, last will and testament. All of these can have irreversible effects. The notaries are the human way and the human control that is requested by the principles of the ELI. Allow me to end this intervention by depicting a scene that is very relevant. In a notary public's practice, there comes a 70-year-old lady accompanied by her new friend. The lady wants to sign a power of attorney for the new friend to sell her house. Her friend is younger, she's more familiar with the documents, and she wants her new friend to get the money for the transaction. It's easier for her because the new friend has a bank account. On paper, everything is simple, but the law asks for the notary public to ask the lady if she read the contract, if she understood its effect, and then to give her consent. And in those moments when the notary public asks the lady, have you established a minimum price for the sale? Wouldn't it be better for you to open a bank account and to collect your money yourself? How long have you been knowing your friend? These are precisely those moments that bring to light the information that an online form cannot seize, such as a lack of discernment, temporary lack of discernment, or a lack of experience that another party can take advantage of. In the online, the same old lady could have ticked the boxes in 3 seconds, and the terms of conditions of several pages long, nobody would have asked her if she understood what she read. The questions asked by the notary public are not just a formality, it's the moment where a human being checks whether the will expressed is the actual will of the person. Thank you.
Mulțumim pentru această
Thank you for this presentation on this multifaceted concept of vulnerability. And now it's time for the last intervention. An intervention on how the AI-generated works must be protected, and how they are protected at present. And the next speaker is Dr. Sonia Flora, an associate researcher at the Legal Research Institute Andrei Rădulescu. Good afternoon, ladies and gentlemen. I have the great honor to participate in the launching of the ELI Romanian Hub. Thank you very much for having me. I am going to speak about the legal protection of AI-generated works. I have a PowerPoint presentation. Now the presentation is ready. I have to practice a little bit more with the technical part of the presentation. I'm going to try and present very briefly a study, and I have some main ideas that I previously developed in another study that has been published in English language. This is a very important topic nowadays, that is a topic of concern for the whole human society. Precisely because these AI tools are extremely dynamic and create pressure on the whole human society and on our lives. They generate pressure on the normative framework as well when it comes to the intellectual property rights. This study tried to give answers to certain uncertainties regarding the legal regime applicable to AI-generated creations. Do they enhance the productivity of the works of the creations? Yes, they increase indeed the productivity, but there is huge uncertainty regarding the legal regime applicable to them. This study was centered around three main questions. The copyright, as currently regulated, is it able to protect the human creations obtained by human with the support of the AI? Second question, the related rights under their current regulation, do they protect these works? And the last question, is it justified now to create new legal tools, sui generis protection, as I call it, in order to protect the AI-generated works that cannot be protected neither through copyright nor to the related rights because they do not meet the requirements of the legislation in force? Now, speaking about the first question, in my opinion, it is essential for us to answer the question if the existing copyright can protect creations and works obtained with the help of the artificial intelligence, only if we are familiar with the basis and the development of the copyright. What are the bases of this right? First of all, the copyright have been developed starting from a principle, the principle that a human being is the only entity that has a self, a personality that is able to express through creations of its human intelligence. We speak about on anthropocentrism, and Professor Laua also noticed it in her presentation. All the rights generated by the human being so far are centered on the human being, on the ultimate interest of the human being. This fundamental principle is deeply rooted in the international conventions, in norms of public international law, in the European law, and in the domestic law as well. The first international convention from Bern in 1986 is the cornerstone in terms of copyright. It established a minimum level of protection. Article 1 of the said convention says that legal protection is provided to the rights of the authors, human beings, natural persons, who have that right on their works by the simple fact of being their creators. Their status of authors is presumed simply because they published a work under their own name or under a nom de plume. The consent for the publication of their work can only be given by the human being. This is a fundamental requirement in order for copyright to be acquired. Then Article 6 of the same Bern Convention establishes personal non-patrimonial rights or moral rights. And obviously, the only one to benefit of this right is a human being. The legal person can get patrimonial rights, but they do not stem directly from the creation, but only based on contracts they have with the authors of those works. Then the duration of the protection of the copyright, it is established based on the duration of the author's life and from the moment the author dies, and only human beings can die. Copyrights react to technical evolution. This is a fact. And this was obvious in the Treaty of the World Organization for Intellectual Property Organization on Copyright. The Copyright Treaty from 1996. This focuses on the evolution after the emergence of computer software programs and databases. The European Union is a signatory party of this OMPI Treaty. This OMPI Treaty reaffirms the obligations that the party committed to under the Bern Convention. And as a signatory party, the European Union is bound by all the obligations assumed by all the member states under the Bern Convention. We know that the European legislator adopts European legal norms such as directives and regulations. Directive 29 from 2001, the InfoSoc Directive, managed to harmonize a part of the patrimonial property rights and the related rights. The European Court of Justice interprets the provisions of these directives and helps us clarify the fundamental legal notions. More precisely, what a work that can be protected through copyright means. Such a work, according to the ECJ, mean an intellectual creation that belongs to a human creator. This means that there has to be a direct connection between the work itself and the intelligence of a human being. The second mandatory condition is for those intellectual creations to be original, genuine. The originality is not always a condition for getting the copyright in the common law system. It is very important for us to bear in mind the significant differences between the legal regimes in the continental law system, called the author's rights, and the copyright in the common law system. If, from a linguistic point of view, the author's rights fully complies with the copyright term, from a legal point of view, this is not the same. And if we do not consider the legal differences, we might end up not understanding what we talk about. For instance, phonograms are protected in the continental system through related rights that are called in English related rights or neighboring rights. In the common law system, they are protected through copyrights. That translates in Romanian as author rights. But the content of these two rights is completely different. How these rights appear, how they are protected, all of this is different. Also different is the meaning of originality. In the common law system, a work is original if it is not a copy of a pre-existing creation, while in the continental system, including in the UK, an original work is original if it is the expression of the author's personality. The ECJ has many opportunities to explain what the concept of originality means. A relevant decision is in the case Mio and Connectra from the 4th of December 2025. In paragraph 50, ECJ says that the reflection of the author's personality in the object through the expression of free and creative choices of the author is a mandatory condition of the originality and then the protection of the author's rights under the European law. In order for free and creative choices to be made, this means, first of all, that the human being has the rational capacity to make a conscious decision on the creative elements of their work and to make this choice freely. And this means having a discernment, and human beings are the only ones to have this discernment. In order for a choice to be free, it means that it should not be based on technical constraints that do not leave room to imagination and creativity.
For AI-generated works, there could be technical constraints like the algorithms and the training data for the system. Because algorithms underpinning AI break the connection between the choice of the user or the instruction given by the user to the system and the generated work. The prompts, the instructions provided by the user cannot control the algorithms of the system. Training data can limit creativity to what the AI system already knows, meaning something that already exists or pre-exists. But copyright is not refused to works of art just because they were created with AI tools. But the conditions are the same. The creation or the result gained through the use of artificial intelligence should be a work of art, meaning it is attached to the human creator, and it should show originality in the sense of the free and creative choices of the author. What it is actually important to understand how copyright is granted. The law presumes the quality of an author through the mere fact of publishing a work, but does not presume the originality of the work. Originality should be substantiated for those who require copyright, even if the work was created through the use of AI. The ECJ ruled in a case Mio and Connectra that these elements should be free and identifiable in the work of art for which the copyright was asked. Of course, this is the approach of various courts in the EU. For instance, the Districtual Tribunal in München on the 13th of February 2026 specified that copyright should be granted to the majority use of human intervention at the expense of AI. This prevailing influence should be shown not in prompts but in outputs. The prompts as such are mere ideas. They cannot be protected through copyright. They are excluded from protection. Essentially, the human influence should model the final result generated by AI in a objective and clearly identifiable way. The one who applies for copyright should prove the fact that the creation obtained through AI provides for a free and creative contribution of the human being. So the AI is rather used as a tool, as a human aid, not as a creative tool and completely independent from human control. The Italian law number 132 of 2015 is the first such law adopted in Europe. It is about the protection of AI-generated works of art. This law admits that such works can be protected by copyright only if they are the result of intellectual efforts of a human being. And then the copyright is granted according to the Berne Convention of 1967. So nothing is changed there. The same reasoning was followed by the Municipal Tribunal in Prague on the 20th of June 2023. Taubel Legal had the force and the courage that the prompts given to the AI system are not expressions of personality but mere ideas, exempted from copyright. So the personality should be reflected in the object which is supposed to be protected. And the AI is just a tool. Is the situation any different in the USA? Because from there we have most of the developers of AI systems. In the US, there is no exception to the rule. The Copyright Office report on copyright and AI from the 29th of January 2025 has the same approach, reaffirming that copyright protects human creation and cannot be expanded to AI-generated works of art without human control. The prompts of the users contain ideas that cannot be protected by copyright because it cannot control the way in which algorithms create a certain result. This is quite an interesting report to read. It is possible that an AI system determines some of the elements of the output. The algorithm breaks the connection between the prompting human and the result. So the user that obtains a work of art by the use of AI should identify concretely and objectively the creative contribution to the output. And there are indeed ways to control that. The selection of the material, the coordination, and the creative amendment of the result. It's like a piece of stone that the sculptor begins to carve. So this is the raw material, so to speak, according to the vision of the European Court of Justice and the US. In Japan and China, it was provided that only humans can be creators, and copyright should be founded on evidence of human contribution to the expression of the work of art, not the ideas. What about the related rights? Are they enough to protect such AI-generated creations? These related rights were later instituted, much later, through the Rome Convention of 1961, followed by the WIPO Treaty regarding interpretation, executions, and phonograms, WPPT, which actually responded to technological challenges. These related rights were instituted in the benefits of interpreting artists for their own interpretation, to the benefit of phonogram producers, meaning audio recording, for radio broadcasting and television broadcasting corporation for their own shows. As a result of the developments in technology, Directive 720 of 2019 regulates related rights, the DSM directive, for the benefits of press editors for specific online uses of their press publications. If we speak about this type of creations, how are they protected through related rights? The criterion is the economic investment, not originality. This is the rule. The exception is in case we are speaking about interpreting artists. The same exception does not allow for patrimonial, non-patrimonial rights, but only patrimonial rights. So related rights can arise with those persons that invest in the creation of such related rights protected objects. There is a specific category, but they can be protected whether there is a human creative contribution that is the expression of human personality. This does not interfere with related rights except for interpreting artists. Now, the legal regime applicable to musical production generated by AI, concluding that although there may be no human contribution, so we are speaking here about music exclusively created through the use of AI. Phonogram producers benefit from related rights on registrations, on recordings, and when we speak about radio rights, in case they broadcast musical creations done through the use of AI with no human contribution. The current regime is the following when it comes to copyright and related rights. Can we actually apply fully this regime to AI-generated works? Yes, but there is a multitude of such productions, produce products that do not benefit from protection. So, is it justified to regulate a new related right specially conceived for that? It is limited as a scope of protection and time for those works that are generated or with or without a general contribution. If this is done to the benefit of developers of AI, this would allow them to recover their enormous investment amounting to hundreds of millions of euro or dollars. But if the new related rights should be granted to the users, this would solve some difficulties, those related to the identification of AI-created works, because that's a problem too. Many times people may reach exceptional creative results by through using AI, and I don't admit of doing so. It will solve the problem of false claim of copyright. We know that the protection granted by copyright lasts up to 70 years. And there are such false claims as to ownership of a work of art. But it may take us to the explanation and clarifications about how AI works. The creators many times don't understand how the system works. So it's very difficult to explain if an AI system really works as a tool under human control, or it is a process, rather automated process in which the algorithm actually controls the output. Another problem is liability for AI-generated works. There are strong arguments against such an additional related right. There are many such studies. This new regulation could turn against the development of AI, some say, because new monopolies are created on the output. And the biggest battle is for new training sets of data, if indeed we want to regulate the output. If we it would be pretty impossible to have new data sets to train the AI. Of course, the IA-generated output have a minimal life cycle, which is actually under the constraint of the market, which would not allow for the recovery of the investment put into developing the system. So the risk would be higher than the benefits. There are other legal tools that are now implemented, technological measures to promote unfair competition and so on, which allow for the recovery of the investment.
Totodată,
Moreover, if we consider the anthropocentrism and the fact that human beings still know how to defend their interests, they are aware of their interests, and they have the discernment as to the consequence of their deeds, then we need to be aware that the fact of encouraging and increasing massive production with the very high speed and low costs when it comes to the content production generated by the AI, this would have the effect of replacing human-created works, and this would weaken the human beings' creative power and their ability to communicate from person to person directly. So we have, on the one hand, the communication between two human minds, and on the other hand, the communication between the algorithm and the human mind, and then we have the communication from algorithm to algorithm. As human beings, we have the responsibility to preserve our abilities, our skills. And for these reasons, the excessive production of AI-generated works would undermine the actual copyright and related rights system. These were designed in order to encourage creativity, ingenuity of the human being, in order to educate and cultivate the human mind and soul, and to help human civilization to develop. In conclusion, this regulatory option has already been subject to public debate in the UK and US, and the conclusion they reached was that there is not enough data to substantiate such a legislative intervention. The European Parliament made a resolution on the copyright and generative artificial intelligence. The resolution dates from March 2026 and stipulates that the existing legal regime needs to be fully complied with when the artificial intelligence is used. And in this resolution, the European Parliament focused on the fact that the artificial intelligence-generated works that do not comply with the copyright and the related rights as established should become part of the public domain. And the status of works that are part of the public domain should be very clear. But the same resolution states that international convergence is needed in order to set up a global regulatory framework. And the monitoring of this quick evolution of technology is required. One never knows if at some point in time we might need legislative intervention in this respect. And now I'm about to conclude, and I apologize for being too long. But I want to end with a quote from a book called Memories from the Future by Irene Vallejo. I read this book, a book that is very dear to my soul, and let me quote. Irene Vallejo says, "We are a fragile species." This was actually said by one of the previous speakers, and this wonderful writer says this. We are extremely fragile. We have the longest childhood, and we are deprived from defense. But we have a wonderful and amazing feature that leads us towards an unexpected development and unpredictable progress. The faculty is our imagination that, together with the language, allow us to dream of unconceivable things, to collaborate and to strengthen each other. We are the only species whose real power is the power to create. And thanks to our imagination and to our creative power, we invented the Icarus myth and the planes and the space trips and the Apollo 11 mission. If we, the human beings, hadn't explored phantasmagoric places such as the El Dorado and phantasmagoric beings like the mermaids, we wouldn't have been able to explore unknown territories. We wouldn't have been able to go to the moon to create the cars or the computers. And I would add here the artificial intelligence. The impossible needs to be dreamed about first by the human beings, as human beings are the only ones that have imagination and creative power. I am confident that the human beings were able to create artificial intelligence tools, and the same way they will be able to create tools that will position the human being at the center of the metaverse and of the artificial intelligence, and at the center of any other reality that might be created by the human being. The human being was the one to create these realities. The human being understands them and needs to control them for the benefit of the human beings. Thank you.
Mulțumim pentru intervenție.
Thank you for your intervention. I think this final quote will kind of summarize all the four topics approached today: the digital constitutionalism, the artificial reality, the artificial intelligence, and the vulnerability. This being said, I want to thank you all for your attendance, for your interest, and I hope these excellent presentations convinced you that the ELI Romanian Hub is indeed a place for dialogue, where all Romanian legal experts can contribute to the development of the Romanian